In Britain, the UK press has never been independently regulated. Instead, newspapers have always marked their own homework and given themselves A grades, even when they've published falsities, intruded on the grief of private people, discriminated against marginalised groups, or even broken the law. In 2013, Leveson recommended that from now on newspapers should be independently regulated to protect the public and improve trust in the press. However, Leveson predicted that most newspapers would not choose to be regulated. After all, they've spent decades doing and saying what they wanted to without consequence. So he proposed a system which is now known as Section 40. This simple legislation would do two things. Firstly, for those newspapers which agreed to sign up to an independent regulator, it would protect them from paying expensive legal costs when defending claims brought against them. This would help ensure that all newspapers can investigate the rich and powerful without fearing the risk of being shut down by expensive litigation. Secondly, newspapers which refuse to be independently regulated would have to cover the costs of claims brought against them. This would mean that ordinary people who are not wealthy could still have access to justice if they were unlawfully targeted by the press. And in any of these cases, the judge would be able to award costs differently if they felt that the law was being abused. In summary, Section 40 would protect regulated newspapers from the attempts of the corrupt and powerful to shut down legitimate reporting, while protecting the public's access to justice against millionaire newspaper publishers. And perhaps most importantly, in doing so, it would provide an incentive for newspapers to sign up to independent regulation, which is better for everyone, the public and the press alike.